Welcome back to this final session in contract law, where we have considered acceptance for the most part, but in this final segment, we are going to consider intention to create legal relations as well as certainty of terms. And this should take us over the next 15 minutes or so at most, because these areas are pretty straightforward, and therefore it is just a matter of you ensuring that you know what the rules are in relation to these. If you get questions like these on the exams, most definitely you are considering these to be pretty straightforward ones that you can just eat up as you like. Now then, what do we mean when we talk about intention to create legal relations? Well, the starting point is when you look at parties within a contractual relationship, the question is, even in the presence of offer and acceptance, and even where the parties have given consideration, did the parties intend for the agreement to be legally binding? Meaning, did they intend that when they made that agreement, if something went wrong, it would be a matter that they would take to court? Well, these types of relationships are broken into two types of situations. We've got commercial and we've got personal. So let's have a look. There is a presumption, of course, that for commercial agreements that parties intend to be legally bound. It is a presumption. So the point about presumptions in law is that they can, of course, be rebutted. So there is a presumption that parties intend to be legally bound when they are dealing in a commercial context, unless the parties expressly state that they do not want to be bound, in which case the presumption is rebutted. On the other hand, many kinds of domestic and social agreements are unenforceable on the basis of public policy. Again, can be rebutted by evidence to the contrary. So for instance, when you look at children and parents, it's no good if a parent says to his 7-year-old child, I need you to run an errand for me, and the child said, fine, you'll have to give me £10 for that, and if the parent doesn't, then he's liable in court for it. It is unlikely to be the type of situation that would give rise to any kind of contractual claim. Now, in social agreements and domestic agreements, if you look at these, the idea is that the presumption is that the parties did not intend to create legal relations. Now, the point, of course, is that just because this is a commercial relationship, or just because something else is a domestic relationship, does not mean that automatically, commercially, there is intention to create legal relations, and domestically there isn't. You simply have to look at the situation factually. You start with the presumptions, but then you look to see whether or not there is anything on the facts which will rebut the presumption. So if we start off in terms of social agreements and look at the early example in the case of Balfour and Balfour 1919 case, well, using sort of contract-like terms, Mr. Balfour agreed to give his wife £30 a month as maintenance while he was living in Sri Lanka, which was Ceylon at the time. Now, once he left, they separated, and Mr. Balfour stopped the payments. Mrs. Balfour brought an action to enforce the payments. Now, at the Court of Appeal, the court held that there was no enforceable agreement, as there was not enough evidence to suggest that they were intended to be legally bound by the promise. Now, that is clear. It's a husband and wife, and it's highly unlikely that every time a husband says something to his wife that he's intending that in the absence of him not doing what he was told, then it could end up in court. I think you would agree that the courts would nonetheless be completely clogged if that was the case. But just because it is a husband and wife scenario does not mean that there cannot be sufficient evidence to rebut the presumption. Now, the case that is often cited in contrast, of course, is Merit and Merit. And in Merit and Merit, the court distinguished Balfour and Balfour because Mr. and Mrs. Merit, although they were married, they were estranged at the time the agreement was made. Therefore, any agreement between them was made with the intention to create legal relations. The point, of course, was that when they made the agreement, Mrs. Merritt was very adamant that he needed to put it in writing, smart woman, but it meant, of course, that it had legal effect in contrast to, say, the Balfour and Balfour scenario. Now, in Merritt, the husband had left the matrimonial home, which was owned by him, to live with another woman. The spouses met in the husband's car, and he agreed to pay her £40 a month, out of which she would keep up with the mortgage payments on the house. The wife refused to leave the car until he signed a note of the agreed terms and an undertaking to transfer the house into her sole name when the mortgage was paid off. Well, the wife paid off the mortgage, but the husband refused the transfer. Now, although this was an agreement between a husband and a wife, it was obvious that it was different from Balfour and Balfour. The husband and the wife here were not living in amity when the agreement was made, and the surrounding circumstances all suggested that there was an intention to create legal relations. And of course, as I say, the courts are going to take that on board. Now, of course, if we look at certain other types of relationships in the context of the social arena, case, of course, that I want to flag up here is Jones and Padda Vaughton in 1969. It was an agreement whereby a mother bought a house in London for her daughter to live rent-free whilst the daughter attempted the bar exams. The court said that it was not legally binding. In Parker and Clark, the defendants invited the plaintiff to live with them. There was a detailed agreement about the household's expenses and that the defendants would leave the plaintiff a share of the property in their will. On the strength of the agreement, the plaintiffs sold their own house and lent money to their daughter. It was held that there was an intention to create legal relations. Simpkins and Pays. Here we see a woman, her granddaughter, and a paying boarder all took part in a weekly competition organized by the Sunday newspaper. The arrangement over postage were informal, and they made entries into a prize draw in the grandmother's name. Now, one week they won £750. Now, the paying boarder was denied a third share by the other two. The court said that there was a legally binding agreement that the prize money should be divided into three. And if you look at the case, it seems that the fact that you had an outside individual who was not a relative or a family member included certainly gave it some degree of credibility. And that is what I would ask you to consider. Now, in respect of commercial agreements, the starting point, of course, is that there is an intention to create legal relations. The case of Edwards and Skyways certainly upholds this principle, but we will start with a case Rosen, Frank and Compton brothers. Now, this was a commercial agreement in which A, who was a British manufacturer, appointed B to be its distributor in the USA and expressly stated that it was not subject to legal jurisdiction in either country, and that was expressly stated. Now, A terminated the agreement without giving notice as required and refused to deliver goods ordered by B, although A had accepted these orders when they were placed. It was held that although this was clearly a business agreement, which appeared to be a contract, it was the express statement which was fatal, because it showed that there would be no legal consequences. And so the court said, if you're going to start making a gentleman's agreement, then certainly the courts are not going to get involved. Now, in the case of Edwards and Skyways, which I mentioned, certainly it stands for the general rule. Now, this was a case involving an ex gratia payment, and the courts there emphasized that there's a strong presumption that commercial agreements are meant to be legally binding. An interesting case, of course, is Jones and Vernon pools. Now, for those who are aware of the lottery now, the pools are a pretty old phenomenon in England. It was where you would mark off the football clubs who would possibly be drawing their match for that week, and if you had a certain number of score draws, you would win. And the idea was that you would mark your pool's coupon, put it in the post, and it would go off to vernal pools. Now, if you bear in mind that this is all about the post and so on, the idea then, it should have been that acceptance would have been in place once it was posted, going back to what I said earlier. But what we're looking at here is that Jones alleged that he had sent in a winning football coupon to Vernon's, who denied that they had received it. The pools company, doubtless to meet such a situation, had printed on the coupon these words: "This transaction is binding in honor only," because clearly persons could afterwards say, well, this is where the ball should have been, or these are the score draws. Jones sued for his winnings, and it was held that the honor clause meant it did not intend to have legal relationships. Now, as I say, that era tends to get a little bit overlapped with consideration, or you might get a somewhat straightforward question in that area. But the point, of course, is that that is, in a nutshell, what you need to know in that area. Let's turn to certainty of terms in a contract. Well, despite the fact that one can find a valid offer and acceptance leading to an agreement, the courts may nevertheless fail to find that there is a binding contract between the parties. Now, such a conclusion may be reached where one party has raised as a defense to an action for a breach of contract the fact that some essential element had been omitted from the agreement, or that the terms were so vague that the contract as a whole is rendered unenforceable. Well, there are two rules when we consider the certainty of terms, and they are these. The contract is uncertain but has yet to be performed. Okay, so what we have are vague terms, but the contract has yet to come into being. Well, vague terms will render the contract unenforceable, and the case for that proposition, as it will be for the second, is of course Scammell and Nephew and Housen Limited. The next situation is where the contract is uncertain, but it has started. Well, it appears that the vague terms are more likely to be enforced by the courts, because clearly, even though the terms were vague, the parties are operating on some degree of understanding. Now, in the case of Foley and Class E coaches, the court did consider this. So if we look at each in turn, the contract is uncertain but has yet to be performed. The attitude of the court here may be seen, as I say, in the case of Scammell, where the respondents agreed to purchase a new van from Scammell. The order was given on the understanding that the balance of the purchase price can be had on higher purchase terms over a period of 2 years. Now, Scammell accepted the offer, though the term higher purchase terms was never determined. It was held that no precise meaning could be attributed to the clause, as higher purchase agreements varied widely and thus there was no contract. What about where the contract is uncertain but performance has commenced? Well, again, in this situation, the courts, as a matter of expediency, are much more likely to uphold a contract. Now, in the case of Foley and Class E coaches, 1934, the plaintiff was a retail dealer in petrol contracted to supply the defendants, who ran a coach business, with all the petrol they required at a price to be agreed by the parties in writing from time to time. Well, no such agreement as to the price was ever concluded, and 3 years later, the defendant purported to repudiate the contract. It was held that they were not entitled to do so, since in the absence of an express agreement, a term would be implied that the petrol supplied by the plaintiff should be of reasonable quality and sold at a reasonable price. Undoubtedly, the fact of the contract having been performed was a major factor, it appears, in the Court of Appeals decision. Well, that brings us to the conclusion of this session, and we have now seen, of course, how acceptance will arise, and we have also seen intention to create legal relations, and also how certainty or uncertainty of terms will operate in a contract. That ends this session.